Especially when you are given an extended lunch. Okay, just suppose we will start with just quickly checking the whereabouts of Advocate Mpofu. Is the public protector back? Public protector, are you there? Okay. The public protector is not here yet, as well as Advocate Mpofu. We want to resume, colleagues. I will quickly, before I hand over to Advocate Mpofu, I'm going to ask the evidence leader to just reflect on one quick issue before, but maybe I want you to do that when they are in the system also. Just announcing that. Honorable Dana, are you on the platform? Honorable Dana? Honorable Malesi, Mamneli, are you on the platform? It looks like it's only Mr. Kekana who's on the platform. Honorable Maneli, can you hear us?
Sheikh Imam is on the platform.
Thank you, Sheikh Imam.
Papa is on the platform, Chair.
Kings. Welcome, Mangits. Okay.
I'm also here, Chair.
I indicated that.
Honorable Zungola, are you on the platform?
To corner slide.
Of course. Honorable Mautwe, are you back?
I thought you got glasses, so that makes you having 4 eyes, Chair.
I can see you back in your own way.
I'm also on the platform, so Mr. Judith Chabalal.
Nemadzinga, you back. Thank you.
Yes, Nemadzinga is in. Thank you, Chair.
Thank you. Advocate Mpofu, are you back?
Yes, Chairperson, I'm back. Thank you.
Okay. Thank you. We were just waiting for you before we...
I apologize, Chair. We was just struggling to get back on. Yeah.
No problem. Just before I hand over to you, I'm just going to ask Advocate Bauer to just raise a quick thing before I hand over to you. Advocate Bauer?
I had neglected to do one thing. I wish to refer the committee to a media report and a response to questions, but I furnished it to Advocate Mpofu only yesterday, so I'm going to deal with it tomorrow instead.
Okay, thank you, Advocate Bauer, for that reference. We're now ready to start our afternoon proceedings with the cross-examination. I now recognize Advocate Mpofu.
Thank you, Chair. Yeah, good afternoon, Mr. Kekana.
Good afternoon, Advocate Mpofu.
How are you this afternoon?
I'm okay. Yourself?
I'm very good, thank you. Right. I just need you to assist me before we get into it, Mr. Kekana, because there are, I have some problems with my list of witnesses here. I've got columns and I want to put them into particular sections. So I want to know where I should fit you, because we've had problems with the previous witnesses. The first witness claimed to be an expert, turned out not to be one. The other one said he was a whistleblower and he also turned out not to be one. You have described yourself as a whistleblower, correct?
No, I haven't testified that I was a whistleblower.
Yeah, but effectively, you are a lawyer, are you not?
Yes, I'm an attorney.
Yes. So when you've said in your statement that you were acting under the Protected Disclosures Act, correct?
Yes, the affidavit that I submitted it in terms of the Protected Disclosure Act.
Yes, that's what I mean. Okay, if you don't, in case you don't know, if you do that, then you are called a whistleblower. Do you know that?
Sure, I'll take your view.
Pardon?
I'm saying yes, I'll take your view.
It's not a view. That's what a whistleblower is. Somebody who acts under the Protected Disclosures Act, or other way around. If you act under the Protected Disclosures Act, then you are a whistleblower.
Correct.
So that's I'm just being as I say, yeah, I just want to know where to put you, because I put you under two different categories, whistleblowers, and then I also put you under disgruntled employees. Which one are you?
You may put me wherever you feel, Mr. Mpofu, or Advocate Mpofu. That would be not my viewpoint, or I wouldn't agree with your viewpoint, but you may put me wherever you feel.
Okay, but
it's fine for you.
Yes, okay, no, then I think I'll put you under disgruntled employees. You agree that you are not a whistleblower?
Well, you just described me as a whistleblower, and I agree with that I'm a whistleblower.
No, sir, no, please. We're not going to go far if you don't listen to my questions. I've never described you as a whistleblower. I said you describe yourself as a whistleblower. There's a big difference. You understand the difference between those two?
Can you repeat your question again?
You've just falsely accused me of having described you as a whistleblower. I'm saying you must listen to the question so that we move along together. I've never described you as a whistleblower, so don't try to be overly clever. I said you describe yourself as a whistleblower.
Chair, that's a pause, Advocate Mpofu, Honorable Ngola.
Chair, I think this committee has discussed on numerous events how Advocate Mpofu conducts himself in this inquiry. He is saying to the witness must try to be overly clever. I don't really think that we should be using such kind of a language in this inquiry. Please, Chair.
Thank you, Honorable Ngola. I want to respond to that. Advocate Mpofu, you want to say something?
Yes, I want to respond. Well, yes, I have to respond before you give a ruling. Yeah, because it's about me. Chairperson, I don't know if the honorable member understands what cross-examination is about. This is, firstly, I don't appreciate cross-examination being unnecessarily interrupted, as I said last week. But there's nothing wrong with saying what I've said to the witness. I've said, because he has attributed words to me which I've never used. So maybe I should put it like this, Chair. Mr. Kekana?
I'm listening.
Yeah, please, for us to move properly along together, don't put words in my mouth. I won't put words in your mouth. and don't attribute to me falsely things that I have not said. Are we together?
Noted.
Just before you proceed, Advocate Mpofu, I just want to, you having responded to Honorable Mola, I think for the cohesion of this process, just to draw your attention to both point 6.2 and 6.3 of the directives, because I will be focusing on that. I have listened to your explanation and response, but I want to draw your attention to those two sections. Please
yeah, it's
proceed.
unnecessary. It's unnecessary, Chair, to draw me to any section. I've just explained that and I've even rephrased the question for the benefit of Honorable Mola. But I've explained to him and to you what cross-examination is all about. So I'm aware of the sections, and you can take it for granted that I know what I'm doing here.
That's fine. I don't. It is necessary for the proceedings of this, for me as a chairperson, to draw any member, including yourself, to the adherence of these sections that I've just quoted. I'm not drawing you to those sections on the basis that you would know about them. I'm constantly going to be doing that. Please proceed.
Thank you, Chair. And I hope you also have gotten my plea to you that my cross-examination should not be interrupted.
Yes. I'm also watching. Thank you for that. I will be also alert to ensuring the flow and momentum of your cross-examination, and I will guard against it being disrupted unnecessarily.
Or derailed, yeah. It's not going to happen that I'm not going to be derailed. Let me make it clear. It's just to save time. But any attempt to do is not going to work. Okay. Mr. Kekana, are you still with us?
Yes.
Yes. I'm saying, really, this should not take as long as it has taken. I apologize to you for it. I'm saying, look at your statement, paragraph 4.
Yes.
Yeah, it is not me, but you who describes yourself as. The purpose of this affidavit is to place on record and make a protected disclosure regarding several instances of what I consider to be improper behavior within the office of the public protector. Let's just stop there. Would you agree that that description means that you describe yourself and regard yourself as a whistleblower?
No, that statement clearly indicates the purpose of the affidavit.
Okay, the Protected Disclosures Act is an act, fortunately I was part of drafting that act, that is intended to protect whistleblowers. Would you agree?
I would agree, Chair.
Yes, and therefore by making that statement, you want us to believe that you fall under the category of whistleblowers, correct?
That would be correct, Chair.
Thank you. Sure.
So just a pause, Advocate Mpofu. Just a pause, Honorable Gondwe.
Okay, there is sort of like an interruption in the background. I'm not entirely sure if someone's microphone is on, but I can even, in some instances, hear people speaking and someone sighing.
Yeah,
okay. Just I don't know whether that is with Mr. Kekana or Advocate Mpofu.
No, it's not on our side, Chair. I hear it as well. Honorable Kondo is right. It sounds like a hen or a cock.
Okay. Now we'll try and watch that. Thank you. Proceed, Advocate Mpofu.
Thank you very much. Yeah, as I say, okay, thank you. Mr. Kekana, as I say again, we must try and assist each other. It shouldn't take us so long just to clarify something so simple that is in your statement. But anyway, As an attorney, you know that the purpose of the protected disclosure is to protect employees from harassment, correct?
Correct.
And to protect them from retaliatory harassment by the employer, correct?
Correct.
And a person who has already against whom what we call occupational detriment has already occurred is not acting in terms of the Protected Disclosures Act. Would you agree?
I don't have an opinion on that.
No, it's not a matter of opinion, Mr. Kekana. It's a matter of law.
I don't agree. I also do not agree as well. I'm not so sure where you get that.
Okay. Have you ever read the Protected Disclosures Act?
Yes, I've read it.
Yes, that's where I get it. Yeah. Have you seen the definition of occupational detriment in that act?
I know it's there.
What is roughly? I'm not asking. It's not an oral exam, yeah. But roughly, without you having the act in front of you, or if you do, you can look at it. What is an occupational detriment in terms of the Protected Disclosures Act?
Well, from the top of my head, it would mean that there mustn't be any recrimination for the protected disclosure that was lodged to the relevant employee.
Yes, but that's not what I'm asking you. But what is an occupational detriment?
I have just described, well, an occupational detriment would be following, this is from the top of my head, following maybe the protected disclosure, the employee or the employer would charge the employee for such disclosures. So the charging of that employee would result in occupational detriment.
Yes. What are examples of occupational detriments?
I wouldn't be sure.
Don't remember. Okay, that's fine. As I say, I'm not trying to catch you out. I'll assist you. Section 3 of the Protected Disclosures Act, I'm also doing it from off the top of my head, basically says that an employer is not allowed to perform an occupational detriment against an employee on account or partly on account of having made a protected disclosure. Do you agree roughly?
Well, I haven't seen the section. If you could show me the section, I would maybe agree with you.
You've never seen it. Okay, that's fine.
No, I didn't say I've never seen it. I'm saying that I don't see it in front of me.
Okay, but don't worry about seeing it in front of you, Mr. Kekana. Remember, you are the one who introduced the protected disclosure to us here. So we must, most of the members are not like you and I, lawyers or legally trained. So the word protected disclosure might mean nothing to them. So I thought you and I will assist the members, but let me assist you. I'm saying that the heart of the Protected Disclosures Act is that, and I'm not reading verbatim, I'm just telling you what the heart of the section says, is that an employer is prohibited through that act from performing a occupational detriment against an employee on account of or as a result of or partly on account of that employee having made a protected disclosure. Do you agree with that? You don't have to see if you know the act, you'll know that that's what the act is all about.
I would say generally, yes, I agree, Chair.
Good. Now, what I'm asking you is a simple question: that in that act, what is this thing called occupational detriment? Or what examples? You don't have to give me all of them. This is not an exam. I just want you to understand that when you protected disclosure there, you know what you're talking about, or at least the members must know what you're talking about. So do you know, if you don't know, I'll assist you. You don't know what is a rough list of occupational detriments?
Well, you can refresh my memory.
Yes.
I don't mind that.
All right. The occupational detriment in the Act is defined as a suspension, some form of harassment, disciplinary proceedings, or a dismissal. Those are the ones that I can remember off the top of my head. Would you agree?
Yes, if you are saying that's what's contained in the PDA, I would agree.
Yes, that's what I'm saying. I'm saying that's what's contained in the PDA in section 1, in the definitions section.
Yes, and I said I would agree.
Thank you. Yes, thank you very much. Somebody is kind enough to bring the Act. Okay, just scroll a little bit up. Yeah, thank you. Okay, that's the part that, no, go to occupational detriment. A little bit up, yeah. Stop right there, stop there, stop there, yeah. Thank you. That's what is in the Act, Mr. Kekana. It says occupational detriment in relation to an employee means A, being subjected to any disciplinary action, B, being dismissed, suspended, demoted, harassed, or intimidated, C, being transferred against his or her will, D, being refused transfer, promotion, being subjected to a term or condition of or retirement which is altered or kept altered to disadvantage, being refused a reference or being provided with an adverse reference, being denied appointment to any employment profession, or being subjected to any civil claim, and so on, or being threatened with any of the actions above, and being otherwise adversely affected in terms of his or her employment. Do you accept that then as what I call those are the occupational detriments that are defined? I was asking you to give me one or two, and you couldn't give me, but you can see that there are about 14 or 15 of them listed there, correct?
Yes, I do see them.
All right. And then while you are here, whoever is operating this thing, can you go to section 3? That's the one we just spoke about now, so that we're on the same page. It's a short one, unfortunately, that one. Can you scroll to section 3? Right. That's the one I was paraphrasing earlier, Mr. Kekana, that I say is the heart of this Act. It simply says, no employee or worker may be subjected to any occupational detriment by his or her employer on account, partly on account of having made a protected disclosure. In other words, no employee may be subjected to those 15 things that we spoke about, or one of them, by an employer on account of having been made a protected disclosure. Okay. I assume you know what a protected disclosure is.
Yes, you've just described most or parts of it.
No, I haven't actually. I only defined occupational detriment, and that's all. But anyway, it's fine. I don't want to go into a long thing with you. But a protected disclosure, yeah. There it is. There you are. It's if you make a disclosure to a legal advisor or an employer or a member of cabinet or executive or any other person in accordance with Section 9, did you make a protected disclosure to any of those people?
Yes.
Who?
Member of cabinet and to the speaker. Well, to the presidency and to the speaker.
Okay, which member of cabinet?
I'm not entirely sure, but I did make the disclosure to the speaker and to the presidency.
Yes, which member of cabinet did you make a disclosure to?
I'm not so entirely sure whether the speaker forms part of cabinet. So I said I'm not entirely sure which member I indicated to which persons I lost the disclosure to.
Okay, thanks. Okay, you're not sure the speaker is a member of the cabinet. That's where the confusion is, correct?
Yes, I'm not sure.
All right. Okay, please, Chair, can you please direct whoever it is to mute?
Thanks, Advocate Mpofu. Now, everybody is muted. It's just yourself, Mr. Kekana, and myself here, and it's very quiet here. We listen.
Yeah, thank you, Mr. Yeah, it's also very quiet here.
We're still trying to fix it because we can also hear it, the noise.
Yes, the only way you won't be able to fix it, Chair, is if it's with me or with Mr. Kekana. Mr. Kekana, do you have any control over the background noises of where you are, if you're at home or whatever?
No, I don't. I'm in an office and I'm sitting alone.
Okay, can you hear that noise? Is it not coming from?
I think it's coming from you, where you are.
No, it's not.
Every time you speak, we hear the noise.
Yeah, well, it's impossible to come from here. I'm not making any noise. Anyway, all right. I know you think it's coming from me, but I'm telling you it's not coming from here.
That's fair, Advocate Mpofu. That's fair. We'll find it and fix it. Please proceed.
Okay, thank you, Chair. Right. Mr. Kekana. All right. The point I was really coming to, which I thought was not going to take us this long, is that by the time you made this statement, you had already been suspended, correct?
That's correct.
Yes. So therefore, there was the occupational detriment, according to what I read to you, had already occurred, correct?
Not in terms of this disclosure.
No. Okay. Had a occupational detriment, namely a suspension, already occurred when you made the statement or not?
I was charged at the time.
Mr. Kekana, please, you are a lawyer. Had an occupational detriment or more than one occupational detriment occurred or not occurred by the time you made the statement?
My answer is that when I made the statement, I was already charged.
And you had already been suspended as well?
That's correct.
So at least two occupational detriments had already occurred, correct?
Not in relation to any protected disclosure.
No, Mr. Kekana, I'm going to take longer than necessary here. I'm asking you a very simple question. I took you through the definition of occupational detriments, and I took you through the definition of protected disclosure. I understand that you don't know what a protected disclosure is, or at least you don't know that the speaker is not a member of cabinet. That's fine. for now, for the purposes of this, we will overlook that. I'm dealing with another issue now, which is that in relation to the issues for which you were ultimately dismissed. Very simple question. By the time you made the statement, at least 2 occupational detriments had occurred, yes or no?
I was suspended and I was charged.
Yes, that means at least 2 occupational detriments had occurred. Because I read the definition for you. Please, let's not waste time.
I've given an answer, Chair.
No, and that answer means you are refusing to answer my question.
No, I'm not. I've given you an answer.
But why are you not simply answering a simple question? I'm putting it to you that 2 occupational detriments had occurred, yes or no?
I said I was charged at the time and I was also suspended at the time. Doesn't that answer your question, Advocate?
No, why don't you just answer my question straightforward, yes or no?
Advocate,
why do I need to work out some long route?
Yeah, just a pause, Advocate Mpofu.
Yes.
Mr. Kekana has responded in the affirmative to say he was both charged and suspended.
Chairperson, no, please, you're not allowed to do this. I'm asking the witness.
He has responded to your question.
No, he has not, Chairperson. I'm putting a different question. I know he responded to that question. I'm now asking another question, all right? Which is that because of that answer, would you agree with me that at least 2 occupational detriments had occurred, yes or no? That's a different question, you understand?
Thank you, Advocate Mpofu. Just a pause. Advocate Bauer.
I really don't want to interrupt, but an occupational detriment, the list of A to H arising out of the disclosure. And I think it's only fair that Advocate Mpofu puts that to the witness properly.
Yes.
Okay. Just before I go back to you, Advocate Mpofu, Honorable.
Yes. Listen, I've raised this before, and I'm going to raise it again. Advocate Mpofu has now said you can't do that to you. And I'm afraid, Chair, that you have every right in terms of the directives, in terms of your function as a chairperson, in terms of the powers of Parliament to interrupt him, to stop him from making repetitive statements, to do what is necessary to make sure that this flows. So I find it very disrespectful of Advocate Mpofu to tell you how you are to conduct your meeting.
Thank you, Honorable Mailham.
Can I respond?
For that redirection. I would want us to proceed, Advocate Mpofu, with the witness.
Yeah, but you must allow me to respond, Chairperson, surely.
On what now?
On what I've just been accused of.
Honorable Chair.
Okay, just pause, Honorable Tina Jumat-Peterson.
Thank you, Honorable Chairperson. May I also request that Honorable Advocate addresses you as the Honorable Chairperson of the House. This is a parliamentary committee and a formal committee, and every chairperson should be addressed as the Honorable Chairperson. May I please insist on the correct manner in which you are addressed. It is highly unprofessional and unnecessary. Thank you, Chair.
Thank you, Honorable Tina Jumat-Peterson. Advocate Mpofu, I'm asking that you proceed with the witness.
Honorable Chairperson of the House, I've been asked to address you like that. Can I respond to the statement that was made about what I said?
They do, and proceed with the witness.
Pardon?
Please respond and proceed with the witness.
Yes, I'll do so, Chair. It's not me who made that remark. Sorry, and Honorable Chairperson of the House, the member says that I cannot object effectively. When I say you cannot do that, Honorable Chairperson of the House, that is an objection, and an objection is something that I'm allowed to do. Even if it was a court of law, I'm allowed to object. But what I was saying is that is not.
Who is disturbing you now? Who's disturbing you there? Please proceed, Advocate.
It's you,
disturbing you there.
It's you, Honorable Chairperson.
But I'm not behind you. I'm here.
Yes. No, I'm saying that when I'm raising an objection, then I am. When I'm raising an objection, I am doing so in order to assist the process. And I cannot be stopped from making objection. I was not making an objection to say you may not interrupt me. Of course you may, Chair, which you have done many times. It's your prerogative. The only issue when I was saying you may not do that is to answer for the witness or to say that he has answered my question when he has not. And then you refer to the wrong or an earlier question. That's all really, and I thought we had moved on. So I don't know what the honorable member was.
Let's proceed so that you do continue the cross-examination with the witness, and maybe if you are able, so that there's a lot of traffic there behind you. If you want us to pause and then you fix that, because we don't want anything distracting you.
No, it's fine. It was just my PA. I don't know why she walked behind me.
Okay.
But,
Chair, my hand is up if you don't mind.
And as Honorable Maute, I see every hand. Please, can Advocate Mpofu finish first, and then I'll recognize you.
Thank you, Chairperson. So thank you, Chairperson. Honorable Chairperson of the House, can I please ask for permission, because I know Honorable Tina Jumat feels strongly about this, but I want to know if you are offended if I call you Chairperson, because I'm doing that with all due respect, but for us to move. I don't think for the next few weeks, if I have to say Honorable Chairperson of the House, please don't take it as a disrespect if I call you Chair, because other members also call you Chair. I think the levels of respect must be equal to all of it.
No, Advocate Mpofu, you're allowed to call me Chairperson or Chair.
Yes. And you can read that, I mean Honorable Chairperson when I say that.
Actually, Chair, that's what I wanted to assist you with.
I'm coming to you, Honorable Maute. Just a pause, Honorable Jumat. Honorable Maute?
Yeah, I wanted to assist you on the very point that Advocate Mpofu is raising of calling Honorable Chair. There's no rule like that says you must call people Honorable Chair or Honorable. It just says you can call them Master or Mrs. There's no rule. Honorable Jumat must go and read the rules properly. There's no rule like that. So you can be called Chair, you can be called Master Janji. Thank you very much.
Thank you, Honorable Maute. The point has been canvassed.
Thank you, Chairperson. I object to the fact that you were calling you. And that was incredibly disrespectful.
Okay.
Except that you will be called Chairperson, but definitely not the manner in which you were addressed as you.
Okay.
Thank you very much.
Thank you, Honorable Jumat. Advocate Mpofu, please proceed.
Thank you, Chair. No, Chair, you'll forgive me. I'm not a member of the House. So all I want to register is that if things like that happen, it's not out of any disrespect.
It's well understood. It's well understood.
And when I say that, I don't know if who is allowed to call you, because Honorable Jumat just said, I don't want Advocate Mpofu to call you, but she just called you herself. So if I'm a less of a person and I'm not allowed to say you, then
that's fine. Thank you, Advocate Mpofu. Let's proceed with the witness.
All right. Now, Mr. Kekana, believe me, I'm asking you this for the last time. You said that, or rather, the definition was put up to you. Advocate Bauer has now just made an intervention. This is what, let me explain this to you. The reason why I started at section 3 is exactly for that, there's a connection between these things. The occupational detriment, protected disclosure, the words on account of mean as a result of, and also the definitions of the employer and employee, which is not relevant for the purposes of my question. Now, I'm saying that at the time of the making of the statement, you said, and I make a protected disclosure regarding several instances of what I consider to be improper behavior within the Office of the Public Protector. Now, I'm saying that at that stage, at least 2 of the occupational detriment related to your, which ultimately ended in your dismissal, had occurred. Yes?
Chair, at the time I was under suspension and I was charged.
Yeah, you've already said that, but I've asked you a different question. Don't you understand the question maybe?
Maybe you could expand on the question.
All right, no, I'll just move on. Will argue at the end that you are being unnecessarily evasive on a very simple issue. Okay, the next one is you said when you made that so-called protected disclosure, you did so because you did not want to attract any further charges against you. Did you say that?
I did say that.
Right. Now, in other words, you did not want to attract further charges other than those that had already occurred, correct?
That's correct.
So you did not want to attract any further occupational detriment, correct?
I didn't want to attract any further charges.
Yes, but we know that a charge is also called an occupational detriment in the Act. So you did not want to attract any further occupational detriment, correct?
I have answered that question, Chair.
No, you haven't, but again, I'll move on. The question is very clear and it's not answered. That's fine. Let's move on. Now, how did you think that making the statement would shield you from any further charges, if that was your motive?
Well, because the Act does protect one against recriminations from the employer.
Oh, I see. So you were making this disclosure so that if there are further charges or further acts of misconduct, of alleged misconduct against you, then you would be shielded.
That's correct.
I see. Thank you. No, that's what I suspected. All right. Now, you are here as a subpoenaed witness, correct?
That's correct.
And that is a genuine state of affairs. It's not choreographed or simulated, correct?
Sorry.
I don't understand choreographed, simulated. Maybe
okay, you don't know. Okay, simulation. You don't know what simulation is. Okay, you see,
no,
like
maybe in the circumstances, I don't understand what you mean by orchestrated or simulated. Maybe you could explain.
Yes. Okay. Simulated means when soccer players pretend to be injured, and they're simulating. In other words, it's a feigned state of affairs. So yours is not simulated.
No, I did receive a subpoena.
Yeah, okay, I know that. I'm saying that Okay, let me simplify it for you again. You were unwilling to come and testify.
Yes. That's correct, yes.
Okay, somebody has not muted there. Those voices are not coming from here. And it's okay, anyway, that's fine. Why were you not willing to testify here?
Well, as indicated, I knew this was a public discourse and I didn't want my privacy to be impacted. And my recollection of some certain events may not as good as it was. So I may have an impaired recollection of certain events. And that some aspects, especially revolving around my dismissal, are currently a subject of litigation in the labor court.
Yes, thank you. No, those are good reasons. So one is impaired memory, correct?
Yes.
The second one is the pending litigation before the labor court, which obviously you wouldn't want to jeopardize. Correct?
Yes, I don't want to jeopardize that.
Yes, and you are also aware that you've also given a statement in respect of pending criminal proceedings against the public protector, and she also would not want to jeopardize that. Do you understand? Just like you.
I hear you, Counsel.
I don't know what that means, but I'm saying to you, I'm putting a simple statement. Just as you don't want to jeopardize the proceedings in the labor court where you have been dismissed, presumably your view is that you've been unfairly dismissed. Even more, if you compare that to a criminal proceedings, you would understand why the public protector does not want to jeopardize her case where she is facing something worse than a dismissal, which is criminal proceedings. Surely, agreed?
I don't have a view on that, Chair.
Okay. All right. Well, again, I'll argue that you are refusing to answer a very simple and obvious question. I mean, this is just a matter of logic, but it's fine. Let's move on. The
pause, Advocate Mpofu. Apology for that. I recognize Honorable Mulder.
Thank you, Chairperson. Good afternoon. I understand that Advocate Mpofu wants to follow a certain logic, but it can't be in order for him to say that the witness refused to answer. If the witness says, I don't have an opinion on this, that does not mean that the witness said, I refuse to answer.
Okay. Thank you, Chair.
Thank you, Honorable Mulder. Advocate Mpofu.
That's fine, Chair. No, it's fine. I'll just move on, really. Thanks, Chair. Okay. Yes, you have, I'll argue that you have failed to answer that question, which is the same thing as refusing it. I'll argue that. That's it. I'm going to argue that. Whether it will be accepted or not does not mean I'm not going to argue it. I'm not prepared to argue it right now. Thank you, Chair.
Let's proceed.
Thank you. You, as a lawyer, you've heard of what is called double jeopardy, Mr. Kekana, correct?
Yes, I've heard.
And it is exactly what you're saying. One of the reasons you didn't want to testify, you didn't want to be placed in a situation of double jeopardy where you prejudice your labor court case, correct?
Yes, I indicated that I don't want to prejudice my labor court matter.
Yes, because of the what we lawyers know as a double jeopardy rule. In other words, when you have one set of proceedings affecting another set of proceedings which are pending at the same time, correct?
Yes, I didn't want to prejudice my proceedings at the labor court.
Because of the double jeopardy rule.
Yes, because of that, if you are insisting on that.
No, I'm not insisting. It's the rule. I didn't make that rule. But thanks. I think you've answered this one with your first word, which was yes. Thank you. And you know that the double jeopardy rule is a rule of fairness. It is meant to protect people like you from having to answer anything twice in different forums. It's a rule of fairness in essence. You agree?
Chair, if that's the case in point, I would have to agree.
Thank you. Right. Now, let's then go to the issues that you have raised in your all right, you said paragraph 5, this affidavit is to make a protected disclosure pursuant to the Protected Disclosures Act, in that it discloses information regarding the conduct of my employer, which in my view is irregular or improper. I believe that this disclosure complies with the conditions contained in section 9.2 of the PDA. What are those conditions?
I can't remember them from the top of my head.
Okay, but you believe once again that you believe that the Protected Disclosure Act is meant to shield you from further charges or that kind of thing. That's what you believe the act is for, correct?
That's what I indicated, Chair.
All right. Again, I don't want to argue it with you now. I'm going to argue at the end that that's not the purpose of the Protected Disclosures Act. But be that as it may, let's move on to the content of your affidavit. You joined the Public Protector in 2011, correct?
That's correct, Chair.
Right. Now, Mr. Kekana, I had hoped to ask you to assist the committee in another respect, but from the last few answers, I'm not sure if you'll be able to do so. But let's just take a chance. You are a senior investigator, correct?
No, currently I'm not a senior investigator.
Okay, you were a senior investigator.
Yes, that's right.
Right. So maybe you may or may not be able to assist.
Advocate Mpofu, we can't hear you.
Sorry, Chair.
The volume has gone low.
Okay. How is that now, Chair?
I don't know. It's still
low.
Still bad.
Okay, let me try.
IT to assist. I think the problem is not with you.
Yes, because nothing has changed on my side. How is that still bad, Chair?
It's still bad. It's like you are far.
Okay, maybe your IT can try. I'll also call my IT this side to see if they can't assist.
Mr. Kekana, can you speak so that we can see if it's both for you?
Chair, I
Okay.
can hear very well, Chair.
No, it's fine. We can hear you too. So the challenge is there where Mr. Mpofu is with your IT. We can hear Mr. Kekana quite loud and clear. I think we are not able to hear you properly, and we don't want to miss what you say.
Thank you, Chairperson. I can also hear Mr. Kekana clearly just for the record. So the problem must be on this side.
It must be your mic. You coming up and down. We hear you, and then the next moment we don't hear you.
Yes. Okay, Chair. Can we just pause for a?
We can pause for a minute. No problem.
Just a second. My IT person is coming now. Thanks. Lucy? Oh. Any luck, Chairperson? Is that better? Where is the volume?
Are we winning, Advocate Mpofu?
No, Chair. Just I'm trying to do it myself, but I'm not succeeding.
Mr. Kekana, are you still with us?
Chair, I'm still here, Chair.
You lower now. Your voice has gone low. Can you hear me properly?
Chair, I can hear you crystal clear.
Now I can also hear you crystal clear.
Okay, Chair.
Thank you. Advocate Mpofu, are you winning?
No. How is that?
That's better.
Okay, good. Thank you. I just had to press all the buttons until I got to the right one. Thank you, Chair.
Which is the reason why you must sit here next to me.
Yes, I'll be with you next week, Chairperson.
Thank you. Go ahead.
Thank you. Sorry about that. Mr. Kekana, you were able to hear that first issue about you being a senior investigator.
Yes.
Yes. Now I was saying, and I promise you I'll move away from this if you cannot assist, because it's something that I was hoping someone like you would come. Do you, for the benefit of the members, are you familiar with the theory of investigations in general?
No, not in general, but I was aware of the procedures that we would use at the office in terms of investigations.
Yes, in terms of the manual that was used in the office, correct?
I was aware of that.
Yes. Okay. No, that's not what I'm asking per se, but it might be relevant. I want you to assist, if you can, only if you can, to define the difference between an investigative process and an adjudicative process. In other words, a process of investigation as opposed to, let's say, a disciplinary hearing or that kind of thing. Do you know the difference between the two?
Well, maybe just to try and answer you, I would think an investigation would be some sort of evidence to find evidence in relation to a particular complaint or allegation, and you would conduct an investigation in order to gather the evidence to see whether there's merit. And then you said the second one was, Council?
Pardon?
You said the second one was?
An adjudicative process, let's say a DC or this, what we're doing now, an inquiry and so on.
Well, a disciplinary process or hearing would be where now parties would come and give evidence, and at the end of the day, the umpire would make a decision on that.
Thank you. No, I'm happy with that.
Just before you proceed, Advocate Mpofu, I don't know whether it is by intention that we no longer see you now. There's no camera of yours, or maybe that is how you were fixing the audio, that it's better when we don't see you.
I'm sure it's better for some, but no, it was not deliberate, Chairperson.
Okay, sorry. Go ahead. Go ahead.
Thank you. Yes, no, I was saying, Mr. Kekana, I'm happy with that broad, rough, non-academic distinction. That's exactly what I wanted. So, but I'm asking the question apropos this, which is going to be important for this process going forward. Would you agree that in an investigation, the rules, particular with regard to Audi, are not the same as in an adjudicative process? And let me define by that. For example, in an investigation, and I'm sure you've conducted many investigations, it can kind of take you, you never know where the investigation might take you. Whereas in an adjudicative process, you have, as you correctly say, a set of pleadings and you know what the dispute is about and so on. Agree?
I would agree on that rough interpretation.
Yes, thank you. So you don't, when you are doing an investigation, or surveillance or that, you don't go around saying to the person, I want to give you a hearing as to whether I should take a picture of you. I'm just making an outrageous example for effect, as opposed to if it was a court of law, you obviously wouldn't be able to act in that fashion. Am I correct?
Well, in our investigations, sometimes we would subpoena witnesses to, give their side of the story.
Yes, no, I accept that sometimes, and particularly if those witnesses were unwilling to cooperate, let's say. Correct?
Sure. That's right.
Yes, but no, I'm not talking about those situations. I'm just saying in the normal course of events, when you interview witnesses, one witness might lead you to another witness, and you might get information, from someone. Let's say you are investigating a particular workplace. You might get information from someone in the corridor, telling you that actually this is what happens here, not what those people were telling you. Information gathering in an investigation is completely different to an adjudicative process. I'm going to call an expert on this. I just wanted you I'm taking advantage of you as an investigator to assist the committee if you can. Am I correct?
I would generally agree.
Thank you very much. That's fine. We'll leave it at that. Yeah. All right. Now, let's now then get to the gist of what you have testified about. Starting with the CX investigation, you have testified and you would agree that this was an investigation that started under the auspices of the former public protector, Advocate Tulima Donzel.
That's right.
And that one of the things she had done in pursuit of that investigation was to consult with SSA or NIA, correct?
She consulted or had an interview with Mr. Billy Masetla,
who was the head of NIA or SSA, correct?
Yeah, if I remember, he was a former head of SSA.
Yes, thank you. So the answer is yes.
I have answered.
Okay, you prefer, you don't like answering, giving simple answers to simple questions. Or do you think maybe I'm tricking you if I say the answer is yes?
Oh, sorry, Council. No, I do respond to questions, and I think I've provided an answer, Council.
And that answer amounts to a yes, correct?
Council, I want to answer the way that I'm comfortable in answering. I don't want to be prescribed as to how I should answer.
No, I'm not saying how you should answer. I'm telling you what I read from that answer, and you can disagree or agree with me. Saying from that answer you've given, I take it as a yes that Advocate Madonsela consulted with SSA on NIA. You can say no, you are wrong, Advocate Mpofu, or you are right.
Yes, he consulted with Mr. Billy Masetla.
Therefore, your answer to my question is a yes.
Yeah, you can say yes.
Thank you. Right, then I think we're going to move nicely now. Yeah. All right. So there was nothing untoward with consulting with SSA in respect of this investigation, at least not in the eyes of Advocate Madonsela, correct?
So sorry, I don't understand the question. Maybe can you?
Yes, okay. Knowing what you and I now know, which is that Advocate Madonsela consulted with SSA, you don't find that odd. You like fighting things odd. That's not one of the things you find odd, correct?
Yes, we had to get a version from the SSA chair. So there was nothing wrong with organizing a meeting with the SSA to get their version.
Yeah, okay. It's not so much to get their version. Okay, would you agree that the CX contract, the party to the CX contract which signed on behalf of the South African government was the intelligence agency?
Yes, that's what we understand, the SSA.
Yes. In other words, they were not about to necessarily just give a version, but as the owners, and I'm using that word loosely, of that contract, they were entitled to give an insight as to what this whole business was all about, correct?
We expected a submission from them in regards to the events surrounding the investigation chair.
Yes, and conclusion of that agreement, correct?
Amongst other things, Chair.
Yes, thank you. All right. And the other issue that was raised with SSA was the issue of the potential impact of the investigation on the stability of the country, correct?
I don't know anything about that, Chair.
You were not in a meeting where these issues of stability were discussed?
Chair, I cannot recall.
Okay, so it may or may not have happened, correct?
It may or may not have happened, Chair.
Thank you very much. But just from common sense, you would agree that if NIA or SSA, as it later became known, had any interest in this matter to the extent that they would even go around signing contracts, it must have had something to do with the security of the country or the stability of the country, because they belong to what we know as the security cluster, correct?
I wouldn't be sure about that.
I see. So you think NIA or SSA would get involved in something that had to do with water affairs and not with the security of the country?
I really would not like to venture an opinion on that.
Okay, I'll venture an opinion and you can tell me if it's correct or not. I put it to you that the reason why that NIA owned this process and as I say, even went so far as to sign contracts about it was because it must have had some relationship with the security and stability of the country. What do you say to that?
That's your view, Council, and I can't add anything more to that.
Okay, you can neither deny nor confirm, as they say in the diplomatic circles. Correct?
Chair, yes, I can't venture an opinion on that.
All right.
Just a pause. Just a pause. Advocate Mpofu, Advocate Mayosi.
Thank you, Chair. Sorry, Advocate Mpofu, could you just clarify for us what it is you are putting to the witness? Is that going to be the version of Advocate Mkhwebane?
Maybe you didn't miss. Maybe you missed the part where I said it's common sense. Yeah, I've just said that it is. I'm asking the witness whether, from common sense, he would agree or not agree with the statement that if something is of concern to NIA, it must have something to do with security. If it is of concern to the Department of Housing, it must have something to do with housing. Or if it has something to do with, I don't know. Yeah, that's just a common sense statement. But if he says he can't agree with that, or he doesn't neither agree or disagree.
Okay, proceed.
Thank you, Chair.
Just a pause, Advocate Mpofu, Honorable Heron.
Thanks, Chair, and I'm sorry for interrupting. I'm just trying to understand is that the proposition is that the CX report was owned, in other words, managed in South African government by the Department of Intelligence or the SSA or the NIA, and that Advocate Madonsela, so the previous public protector, also met with the SSA. I feel like I've lost a little bit.
Do you want Advocate?
I just want Advocate Mpofu to confirm whether I'm following it correctly.
All right, you got that, Advocate Mpofu?
Yes, Chair, and thank you, Honorable Heron. Yes, that was my first question, and the witness did answer that. He confirmed that indeed Advocate Madonsela met with SSA, and yes, Honorable Heron, he confirmed that that was partly because they were the so-called quote-unquote owner. The owner thing is just my word. I'm not going to hold the witness to it here. I just meant that what Honorable Heron is exactly saying, that they were the persons who represented the South African government in this particular transaction. So the only issue I was now raising with the witness was if they were indeed the lead department, as I think that's what it's called, in this particular transaction on behalf of the South African government, therefore it must have had something to do with the security of the country. And the witness says he cannot confirm or deny that. And there's nothing I can do. I'll move on to the next thing.
Thank you. Honorable Heron is clarified. Please proceed.
Right. And Mr. Kekana, one of the reasons why the meeting had to be held was because the transcript or notes or whatever, or any evidence of the previous meeting with Advocate Madonsela went missing. Otherwise, it might not have been necessary to have this meeting if those notes were available, correct?
You are referring to the meeting of with the SSA?
Yes, with the one you referred to, with Mr. Masetla.
No, there was no meeting with Mr. Masetla. The records for Mr. Masetla were missing, and so it was necessary for us to have a meeting with the SSA to get their narrative on the events surrounding the investigation.
What do you mean there was no meeting with Mr. Masetla? I thought we had covered that ground. You and I have agreed, and even Honorable Heron has made sure that we have covered that ground, that there was a previous meeting between Advocate Madonsela and Mr. Masetla.
Yes, there was a meeting previously between Advocate Madonsela and Mr. Billy Masetla.
Yes.
And yeah.
Sorry. So sorry, sir. Sorry, I didn't mean to interrupt you. You can finish.
And upon noticing that we couldn't find any record of that meeting or transcripts, we organized another meeting with the SSA.
Thank you. Yes, no, I think we're saying the same thing. I'm sorry, maybe I didn't put it properly. And I'm saying, therefore, you'd agree that had the transcripts of those meetings been found, it would not have been necessary to have another meeting. I think that's what you're saying.
Yes, it might not have been.
Correct. Right. And because the transcript was missing, this meeting was therefore arranged, and it took place in when?
The meeting took place, I think, on the
3rd of May, 2017, correct?
That's right.
Yes, okay. And that meeting was on the other side, there was Mr. Ramabulane and Mr. Arthur Fraser, otherwise known as King Arthur these days, correct?
Yes, there was Mr. James Maramabulane, Mr. Arthur Fraser, and Minister David Mahlobe at that meeting.
Right. And then this is the first oddity. You say, as I said, you found a few things odd, ODD. You said you found it odd that the public protector spoke to Mr. Mahlobe separately.
Yes.
And do you find it strange that sometimes, you know, the senior people in a particular delegation might have a separate meeting, preliminary meeting, sometimes called a meet and greet, and that kind of thing. Is that odd?
For me, the odd thing was that we usually didn't have one-on-ones, especially during an investigative meeting.
Yes, but well, the version of the public protector would be that that was not necessarily an investigative meeting, but a meeting for the purposes that I've explained, that to get clarity with the from the owners of the contract.
That would be her view, Chairperson. I can't add anything on that, Chair.
Yes, but you can't dispute that view, correct?
Chair, the only testimony that in light of that is that I found it odd that in an investigative meeting, you would have a one-on-one before the meeting.
Yes, Mr.
Thank you. Just pause, Advocate Mpofu. Honorable Gondwe.
Advocate Mpofu, I want to get clarity. When you refer to the owners of the contract, are you trying to imply that the complaint emanates from the SSA or NIA at the time? You referred to the owners of the contract, so I wasn't entirely sure who you were referring to there.
Yes, thank you, Honorable Gondo. Yes, I'm sorry, sometimes I use these terms just for shorthand so that we move on. I don't want to be married to the owner. Let me use the correct term. The signatories to the contract were the SSA or NIA, correct, Mr. Kekana?
Yes, they signed the contract between the government and CX.
Thank you. That's all I really wanted to convey, Honorable Gondo.
Thank you. Proceed. She's clarified.
Okay. Where was I now? I'm saying that I know, Mr. Kekana, what you found odd, and I know that you think it was an investigative meeting, but I put to you the view of the public protector, and as I understand it, you are not disputing. You just said that is her view. You're not disputing it, correct?
I don't know anything about that view.
Yes, therefore you're not disputing it, correct?
Well, I'm not disputing it, not also agreeing with it.
Yeah, no, thank you. I'm clear on that. Yeah. All right. So where did you study law?
Sorry, Chair?
Where did you study law?
University of Pretoria.
Okay. Now, the public protector will say that there's nothing odd when she is involved as a senior person on your side of the delegation, and there's another senior person at the level of a minister or the Speaker of Parliament or someone of that nature, for her to, as a matter of courtesy, to have a one-on-one meet and greet with that person. I suppose you also cannot dispute that.
Chair, I don't have a view on that. I've indicated what I found odd with the incident.
Yes, you yourself had not been in another meeting with the public protector where there had been a minister, correct?
Sorry, Chair, I didn't get that.
Before this, you had never been in a meeting with the. I'm sorry, Chairperson.
You are fading again. It's just starting because we're hearing you correctly, but you've just gone down now. We can't hear you. Okay, Mr. Kekana, can you hear me?
Very well, Chair.
Can you hear me now, Chair?
Yes, Advocate Mpofu can hear you now.
Am I back? Thank you. Thank you, Chair. Sorry about that. I was asking Mr. Kekana if you had been to a meeting. You have never been to a meeting before where the public protector was meeting a person at the level of a minister, correct?
I have on some occasions attended meetings where a particular minister was there.
How many?
Sure, I can't recall. I really can't recall. But I do remember that I attended meetings where a couple of ministers were there.
No, okay, I understand. Cabinet ministers or a minister?
A minister. I specifically remember having a meeting with Minister Mahlobo, naturally. Also remember having a meeting with Minister Igaba.
Yes. Okay. Anyway, your evidence is that you cannot dispute the fact that she normally has those types of interactions with people at that level, correct?
Well, I don't have a view on that. If she wants to put that, that view.
Yes, but Mr. Kekana, please, I need you to help us, please. When I say I put a proposition to you, you don't have to, you must just answer the question truthfully, sir, as you have taken an oath. I'm saying, therefore, I know that you're saying it's her view. We all know it's her view. I've put it to you as her view. I'm simply asking you a simple question. Therefore, you cannot dispute that view, correct?
I wouldn't know, Chair. If she's making such propositions, Chair, I really wouldn't know. I've put my view on what I thought or what at the time I felt was odd, and I can't add anything more to that.
Okay.
Yeah.
Mpofu.
All right, I give up again. I'll add you whatever I add you at the end. But in fairness, Mr. Kekana, to you, I must tell you that I'm going to add you once again that you fail to answer a simple issue, especially when it becomes clear what the implications of that issue is.
Let's just pause there because again, you have gone down. We'll give you a chance. We'll take a 15-minute tea break. And
Okay,
we'll get
Chair,
back after 15 minutes. Hopefully by then it will be sorted.
Yes.
The audio and the sound. For
Thank
15
you, Chair.
minutes.
But can
Just
you
a
hear me
break.
now? Can you hear me now, Chair?
No.
No. Okay,
Yes.
good. Then I'll fix
Please
it.
just try and sort that out. We'll be back in 15 minutes. A tea break, Mr. Kekana. We'll see you in 15 minutes.
Thank you, Chair.
This guy, sir.
Give you a chance, we'll take a 15-minute tea break. And we'll
Okay,
be back
Chair.
after 15 minutes. Hopefully by then it will be sorted.
Yes.
The audio and the sound. For
Thank
15
you, Chair.
minutes.
Can
Just
you
a
hear me
break.
now? Can you hear me now, Chair?
No.
No. Okay.
Yes.
Good. Then I'll fix
Please
it.
just try and sort that out. We'll be back in 15 minutes. A tea break, Mr. Kekana. We'll see you in 15 minutes.
Thank you, Chair.